Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Well, hello, my friends. Today's Monday, September 22nd, 2025. I thought it was Tuesday, but it's Monday. We're going to Plymouth Superior today. I think it's our first time going to Plymouth Superior Court in Massachusetts because AJ's back. I did a story on my Instagram and I said, AJ's back with because I usually promote the shows on my Instagram story. And the song that I put to it was Baby Come Back. Remember that one? Baby Come Back. Any kind of cool fool could see. I can't sing right now because I have no voice, but it was by Player and it's from like the 70s, Baby Come Back. And I just thought it was so appropriate because here comes AJ and he's coming back. And I don't know if Howie Carr's getting any inside dope, but thank you to whoever sent this to me. Here's what Howie Carr has put out there on the Twitter as of 9:29 a.m. I'm going to put it up this time because last time I repeated to you something that Howie Carr said. Everyone said that I was saying it, but I wasn't saying it. It was Howie Carr. I'm also going to ask if any of you are on the Zoom. If you're on the court Zoom, please, 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 for the love of the traveling Mary, please mute yourself because if you are playing me through your speakers or something and you're also on the Zoom, they will hear me speaking and people think I'm the one on the Zoom who didn't mute. And I don't want anybody to think that. There was something and everything about you. That's right, Connie. Baby, come back. Look at what Howie Carr said at 9:30 this morning. Breaking status conference in Karen Reed's civil cases at 2 p.m. in Plymouth Superior Court will be live streamed. Did he say watch Melanie Little? He usually does, but he didn't this time. Maybe somebody can go comment on Howie's watch it on Melanie Little. Okay. Should be big, all in caps. The names of the hacks, corrupt cops, and McAlberts Reed is planning to sue after their failed lynching of her are expected to be made public today for the first time. Ostensibly, the hearing is about O'Keefe's family's suit against Karen for wrongful death, etc. But in addition to asking for dismissal of some of the civil complaints against her, actually some of the counts, Reed's lawyer will also fill in judge on Reed's plans, namely her own impending mega lawsuits against the state police and assorted McAlberts. Alan Jackson is in town for the hearing, but most heavy lifting today will be done by Damon Seligson, local lawyer who will be handling much of the impending civil litigation. You may have seen an interview with Damon Seligson on Larry's channel, DUI guy, but I think he's changed the name of his channel now to, I'm not sure what, Larry Foreman. Seligson is expected to name each and every defendant in Karen's upcoming lawsuit. Should be very, very interesting. In addition to Jackson and Seligson, a bevy of other lawyers will be in attendance for Karen Reed. This is the start of what you might call payback. Oh, Howie. Sadly, Meatball Morrissey is not expected to be named as a potential defendant. Prosecutors in Massachusetts have almost impregnable immunity. Impregnable? Impenetrable? It says impregnable, which also applies to Hank Brennan, the quote, special prosecutor. Hoping to have Seligson on my show sometime after hearing ends. We'll also have sound cuts on the air / live streaming as soon as they occur. Developing ... I mean, I'm here for it. Are you here for it? Court TV's live streaming it, so we can use the Court TV. The Court TV feed, which is what we're going to do. And we have it all modulated and everything else. And I just want to show you guys, because you guys came up with an amazing idea for new merch. And I did it. I got all into the Canva. Check this out. Check it out. Hang on. I'm going to show you. I just want to give credit where credit is due. Zambi Ma'am had this idea. She said, why don't you make a tour shirt? Make a tour shirt. And I said, yeah. And on the back, I can make a set list. And on the set list, I can put all of our sayings on it. And here it is. Here's our tour shirt, our 2025 tour shirt. Maybe when I get as big as Annie Elise, I can really go on tour, because Annie Elise really did go on tour. And I was going to go see her on tour, except then Dave Matthews got involved and I had to go there. And also, as such, like that, visit my kid in New Hampshire. But here it is. Here is your official Attorney Melanie Little XOXO Tour 2025. And it says in the bottom here, it says, well, I can't really read it to you because I can't see it. And this is the set list on the back. So we'll pull up the set list separately and take a look at that. But let's see if we can get it says, get your tickets at Attorney Melanie Little. And then it says, join the snark tank on the bottom. And it's like the old style tour shirts that we used to have. And here's what it says on the back. You can't read it from here. We can read it from here. Let's see if I can go back. And the link to the merch is in the show notes below. And so I thought that was so fun. So let's stop sharing that, and then I'll start sharing this. And we're just waiting for the hearing to start, so we have a little time. Check this out. Here's the set list on the back, starting with God Save Us from the Commonwealth, Call Me Alice, Show Me the Papers, The World is Watching, Grave Concerns, Talk Amongst Yourselves, There Was No Collision, followed by Buy the Tickets, Pin It on the Girl, Under Her Eye, She's Telling Them Everything, We're Not Buying What You're Selling, Upside Down, Inside Out, Narnia of Norfolk County, All Hail King David, A Lefty Scissorhands, Hello, Have You Met Me? Followed by Never Lie to the Ice Cream Truck, One Way Ticket to Block Island, Love Me Some Better-O Letters, Hyperlink Me, For the Love of the Traveling Mary. And then there's two encores. First is We Ain't Got No Quit. And the second encore is I Love You With All of My Heart. Isn't that hilarious? I thought you'd like it. It was your idea. And Zambi Ma'am got her choice of merch for coming up with the idea. So thanks you guys for coming up with that. Comes in a couple of different models as such. And what I will do, if you stick around till the end of the show, we'll do a giveaway. We'll give away a tour shirt at the end to one lucky winner, chicken dinner, Never Lie to the Ice Cream Truck. So I think one of you guys came up with that. I'm sure you did, because you guys are freaking amazing. So, we got that going for us today. I couldn't fit any more songs on there. There were a lot of other ideas that I had, but I couldn't come up with any more. There was no more room left on the shirt, see? So we couldn't do anything more than that, but we got it done. I got it done. It was just me and Canva. That is actually the best money I spend every month, more than StreamYard. It's on Canva. Let's pull up the court feed so people don't get upset and think that we're not going to be there, because we're going to be there. We're there. There's no sale going on right now in the merch shop. So if you want to wait for a sale, I'll tell you when the next sale is going to be, because I think I have access to that. I also put this Wonder Skin lip tint that you guys wanted to know about on my Amazon list, which is also linked below. And so far, so good. I like it. And I also put my sunglasses on there. A lot of people asked about my sunglasses that I had on at the God, their sound up. A little larger. Oh, here's AJ. AJ's back. Baby, come back. Any kind of fool could see there was something, everything about you. Baby, come back.
Counsel, I asked the question that you asked, Counsel. He would like to do status first and the Rule 12s, but he also said to me if you could check your calendars for trial date.
There's Karen, looking beautiful.
All right. Ms. Crack, are we good to go? You let us know we're ready.
So exciting. I mean, it's only 1:55. They're a little bit early. I spy Karen Reed, Bill and Janet Reed. I hear somebody whispering into the microphone. Oh, the hot mic is off. There's Bill Reed and Janet Reed. Hello, America's parents. We love you. I'm pinning the new tour shirt merch in the chat. Oops, so you can find it easily. Oh, there's Tim from Canton Community TV. Oh, the courtroom's pretty full. There's Mrs. O'Keefe, Peggy, and Erin is here today. And Paul O'Keefe and Brendan. He's been on every single documentary that would have him. This is Plymouth Superior Court. Oh, is that wait, who's this in the yellow? She looks very familiar to me. Is she a reporter? Microdots is here. Hey, Richie. Emily C is here. Hey, Now it's pinned in the chat. I recognize this young man in the front row. He was the tech guy that took over for our friend Craig Bates. I think his name is Evan. Is it Evan? Ooh. Karen looking lovely in a very lovely camel colored dress.
Good afternoon, folks. Good
afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with Plaintiff's counsel. And if you could state the party you represent as well. Thank you.
Sound good?
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs. Okay, good afternoon. Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed. Okay, good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay,
Good
good
afternoon, Your
afternoon.
Honor. Christopher George on behalf of the defendant Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay. I'm sorry, did you say the Waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor. Attorney General, also on behalf of Waterfall, Waterfall.
Good afternoon.
Good afternoon, Your Honor. Looking those on behalf of the defendant, C.F. McCarthy.
Good afternoon. Okay.
If you're not looking at your screen, the attorneys for CF Waterfalls and McCarthy's kind of got shoved over into the jury box because there's a huge team.
That's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all were going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents
Well, that's because there's a motion to dismiss pending.
from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor.
Right.
So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant, and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days is my guess.
Okay. All right. Procedural issues from the defendants. We can start with you, Attorney Seligson. Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Bukhenik in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question.
Yes.
Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the house diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the house were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the house was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed. Regardless of how the court decides those, we still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading, serve all of those new parties with that complaint, allow them 30 days, not the normal 20 days, to respond, so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Dillard can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be in a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
You like me
Yes,
now?
Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for under extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Because the tracking order is what it is. We'll get to that in a little
Yes,
bit.
it's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but when there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right. Thank you. Let's hear from C.F. McCarthy, then.
Your Honor, in a similar vote as to Waterfall, we were putting finishing touches on our discovery responses. The last leg of it is just collecting communications from employees thematic incidents, some of whom no longer work for C.F. McCarthy's, but we anticipate having that included in the very short term and getting that over
to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then in terms of the response to the procedural issue that was raised in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not how the
expect
court
that.
system likes this stuff to work, folks.
Right, I would expect the courtesy of the meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to.
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court.
It's okay.
So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct?
Yes,
There's 5 for the plaintiff and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the
You're going to need a bigger boat. You're going to need a bigger courtroom, Judge.
case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? We could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case, but to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial
Come to your screen and look at Paul O'Keefe's ridiculous smirk.
economy without prejudicing the plaintiff. Discovery is already ongoing. But to have two depositions, for example, of parties in two separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I certainly am not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor,
I will tie this all up in a neat little bow for you at the end, but let's listen to them argue the motion to dismiss and thank B. Crumbs for gifting 10 new members. You're awesome.
Counts that are at issue in the motion to dismiss are counts 13, counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. The cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence/reckless/intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is pled in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can. The Waterfall?
Yes, Your Honor, we have the Waterfall. Just very briefly, I think the distinction here the counsel's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't from a relational standpoint close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. It would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell's sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from CF McCarthy's on that. Anything else to add on the motions to dismiss? No. Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course.
Plaintiff
What I was going to
argue?
say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iachino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
He's basically explaining to the audience, the worldwide audience, that it's based on the papers, and what's in the four corners of the complaint, like I always tell you.
Your Honor, thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal...
Yeah, and it wasn't Karen. Karen Reed was not responsible for his death. So remember that, because they've already told you they're going to sue everyone who is responsible for his death, including Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins, in addition to the bumble duck police that you had, Proctor, Bukhenik, MSP, and Canton. So yeah, when you say all of this, understand that you're right. You're right about everything that you're saying, but John O'Keefe was not hit by a car. And so somebody needs to pay for the murder of John O'Keefe, and it's not Karen Reed.
He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving two young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor, JJ is involved in a relationship with Miss Reed. been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at or around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information.
How long did it take for him to mention Turtle Boy? We'll have to go back and find that out later. These are all in their papers, so you guys are freaking out about it. This is everything their papers allege. In the show notes, there's a link to the show where I went over all the papers. And this is what they're alleging. We know it's not true, but they're allowed to allege it.
Through him, she pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has 2 components for damages. It has 2 buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages, the lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Semino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings 2 separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Semino case, Your Honor. Semino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Semino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck
Everybody but Karen Reed knows.
She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I will refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries. Closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendant's argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to—
Okay, why are they zooming in on Karen's hands? Really? Okay, that's ridiculous. But that's the shot.
to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's in the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative.
And more Turtle Boy.
Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos
Oh,
that
shut
got
up.
published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the
The family had never seen the autopsy photos before. Turtle Boy, they are blaming you. He's here. He's in the chat. Guess who left Kaylee home alone when he went out that night? John O'Keefe. She already was home alone. She was old enough to stay home alone. I understand that you're trying to make a big show for the worldwide audience, but we've seen 2 seasons of this show and we know the real facts. So everyone hit the like button, please.
extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this.
That is very sad, but Karen Reed did not kill John O'Keefe. And that is why the defendants want to bring in 10 more defendants who know who did kill John O'Keefe.
She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polite case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc.
Wait, I'm sorry. Did she go on Turtle Boy? Did I miss that episode? Did I miss that episode? Dude, nothing that she said was a lie because she's been acquitted of the death of John O'Keefe. So maybe you should redirect your anger towards the proper defendants that, by the way, you should have sued to begin with. So I don't know, it could be a malpractice case against you eventually when this case is dismissed against Karen Reed because, you know, ARCA is going to come in and testify. So there's that. As is the medical examiner who's going to say that there was no evidence that John O'Keefe was hit by a car, and many other, Dr. Laposada, many other witnesses also who are going to say John O'Keefe was not hit by a car. So therefore, you should notify your carrier, I don't know, in my opinion, because there could be a malpractice case against you for not advising your clients to sue the proper defendants within the time frame allowed, because the wrongful death statute of limitations has expired and you can't do it. You should be happy that they want to bring them in as third-party defendants. Is all I'm saying. I don't know. It's only what I do for a living for over 30 years, but don't listen to me.
Or more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough.
And we ask this through Christ our Lord. Amen.
Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly, firstly, those allegations contained in a complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous. It's at the time of the event.
He's within the zone of danger. Remember, we talked about the zone of danger. Those are traditionally how you can collect on intentional infliction or negligent infliction of emotional distress claims, because you're in the zone of danger of what happened to your loved one.
And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. You also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this, this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to assign a trial date, we could do so. I mean, literally, I've talked to the clerk, we could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it, but nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years.
Hold on. If you Judge Daniel O'Shea, if you think there's any shot in hell that Karen Reed is going to settle this case with the O'Keefes, you got another thing coming. That's hilarious.
You learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers, your clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to do that. The clients can try.
That's true, Your Honor. That's true, Your Honor. They could go on for 20 years. And you know what else is true, Your Honor? Perhaps the plaintiffs shouldn't have brought a frivolous action that they know they could improve after an acquittal. And based on all the medical evidence and the science and the medicine, they sued the wrong people, Your Honor. So you should direct that towards the plaintiff, not trying to tell the defense to settle, because it's never going to happen.
To put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank.
She's already in the hole for $5 million to her attorney. She had to sell her house, liquidate her 401ks, lost her job, her health insurance, her car. But now you're encouraging her to pay more money to these people who have wrongfully persecuted her. Come on, Your Honor. Did you watch either trial? This is season 3, and season 3 promises to be explosive.
Discussions with their lawyers about that, and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, how what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still, it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make ultimately. They're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself.
Why would they ever admit to over-serving Karen Reed? They're never going to admit to that. They're just not. I mean, I it's a good, good college try, Your Honor. This case is not settling. Like maybe the 900 other cases you have in front of you may settle, but this one won't.
A lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you, you could do as soon as this spring if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
In person.
We're agnostic, Your Honor. I'll do whatever.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Of course we do, because we want to see it.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here in Plymouth.
Please do.
I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure. How many days out do you want to go? 60 days, 90 days?
Yeah, probably 60 days.
50 days? November 21st, Friday in the end of November.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly, as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery, and any motions, Rule 15 motions to amend or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor.
All right. Nothing with the jury?
I don't think so. Nothing.
There's Karen talking to Damon Seligson, our South African defense attorney. Let's mute this and we can watch it play out. Hey, here's a great idea. Let's have everyone come back the Friday before Thanksgiving. So everyone that's got to fly in from out of state can pay the highest possible airfare the week before Thanksgiving. If anyone has college kids, you know how expensive, and they go to school plane right away. You know how expensive the plane tickets are the week before Thanksgiving. Well done. Well done. But at least we're coming back in person because we want to see it, as does the world. We'll watch this play out. Karen talking to Damon Seligson. Come and check out. If you haven't seen Karen, she looks great. She's wearing a camel color dress. And I will tie this all up at a bow for you. But first thing I want to do is go back and play what I consider to be the best part of this hearing, which is Damon Seligson, who is the lead defense attorney. There's Alan Jackson shaking his hand. Alan Jackson has been brought in for this case, but as he said to Billy Bush, he's not a civil litigator. And so therefore, he's going to take a back seat to this and to the arguments and to the papers and everything that happens in the courtroom. A lot of you are upset that he wasn't speaking today, but this is not his wheelhouse. This is not what he does for a living. The best part of this case was when Damon Seligson got up and said that he intends to bring in the following 10 new defendants: the Massachusetts State Police for violating Karen's civil rights, Lieutenant Tully, Yuri Bukhenik, and Michael Proctor, in addition to Brian and Nicole Albert, Jennifer and Matt McCabe, and Brian Higgins. And they are going to allege civil conspiracy and the violation of Karen's civil rights, as well as the town of Canton for negligent failure to secure evidence. And the Massachusetts State Police claims are going to be for negligent hiring and negligent supervision. If you have questions about that, I can explain that to you. But let me just take it back so that we can hear that beautiful part of this hearing again. It's pretty awesome.
Seligson on behalf of the defendant, Karen Reed.
Okay, good afternoon.
Good afternoon, Your Honor. Charles Waters for Defendant Karen Reed.
Good afternoon, Your Honor.
Let me just go back to find the right part. Okay, here we go. Oh, Tully. Did I say Tully? I did.
Start with you, Julie Seligson.
Thank you, Your Honor.
Procedural issues from the defendant. Here we go. We're going to hear this again.
As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Bukhenik in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor.
Okay, so let's just pause there for a second. This is what I've been saying since the beginning. I've been saying they should third party in the people that Karen Reed feels is responsible for John O'Keefe's death. And the third party complaint is when a defendant who is sued says, oh, you're suing me for the death of John O'Keefe? It wasn't me, it was them. It was them. And the them that could be the third party defendants are going to be named next. Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe, and Brian Higgins. The first set of defendants, potential additional defendants that he named, are with regard to the violation of Karen Reed's civil rights. And he's right. There are other ways to do this. He could file a separate civil rights complaint. And then because everything involves the same set of facts and the same events, move to consolidate them later. But in order to streamline the process here, the judge says the trial is supposed to happen by summer of 2027. You have the discretion, Your Honor, to allow us to do a different way. You have the discretion to allow us to bring them in and we'll just streamline this. Kevin Reddington was there? I didn't notice. And the plaintiff's response was, these have to be federal claims, and we don't want to go to federal court. Yeah, you bet they don't want to go to federal court. Federal court is so much stricter than state court. Federal court has tight deadlines. It has tight procedural requirements. It has judges who are not as lenient as in superior court, perhaps, in the civil side. And the plaintiff does not want to be in federal court. And Seligson said, well, listen, Your Honor, you do have the right to hear these in state court. There's no requirement that these have to be in federal court. And those would be 1983 actions. But he says he's going to sue Tully personally, Bukhenik personally, and Proctor personally. Moving on.
We bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reid's civil rights, and then a claim against the town of Canton through.
So, civil conspiracy and violation of Karen Reid's civil rights. Not all the occupants of 34 Fairview that night. Brian and Nicole, Jennifer and Matt, and Brian Higgins. No Colin Albert. Not Colin Albert. And then they want to sue the town of Canton, and here's why.
Its police department fights. And then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts.
They do.
In order for us to fairly defend Ms. Reid in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reid, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected.
Police adjacent. He's not even jumping to the conclusion yet of blaming them for John O'Keefe's murder. He's just saying they diverted attention away from themselves, and they diverted the investigation away from themselves in order to pin it on the girl.
Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reid was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we...
No Kerry Roberts. No, they did not mention Kerry Roberts. Well, Colin is not included because the only claims that they're claiming right now are conspiracy to divert attention away from themselves to Karen. They're not saying these people killed John O'Keefe. They're saying they conspired to divert attention away from themselves and focus the police on Karen. And absolutely, nobody even went in the house. I mean, nobody even went inside the house to search the house. We know that.
Emphasize the process to bring these claims and parties in. What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on.
He's giving them an extra 10 days to respond. He's saying, let us answer Here's what they did. They made a motion in lieu of an answer. We discussed that, and I've linked the show below in which we talked about the motion to dismiss. She hasn't answered the complaint yet because the case was stayed during the pendency of the criminal trial. The criminal trial's over. She's been acquitted. Now this case can proceed. Karen's team, led by Damon Seligson, filed a motion in lieu of a motion to dismiss on the pleadings alone, saying they're not asking for the whole entire case to be dismissed, just certain claims, the emotional distress claims. And we talked about it so much at length during that other show that's linked below that I don't want to get into all of that again. Based on the case law and based on other things that we talked about, zone of danger, the time, place, manner, when the O'Keefes found out that John was dead, and they're saying you can't possibly collect on emotional distress claims because they didn't see it happen. And if Karen Reed did say something in front of Kaylee, the niece, which Kaylee testified that she did. Kaylee testified that when Karen came into her room at whatever time it was before 5 a.m., because Karen didn't have Jennifer McCabe's cell phone number, she needed to use Kaylee's cell phone or have Kaylee call her, that Karen said in front of her, John's dead. John might have gotten hit by a plow and then left her home alone. And that was so egregious that it rises to the level of either intentionally inflicting emotional distress on Kaylee or negligently inflicting emotional distress on Kaylee. And it's my opinion that if Karen said that, and the court has to accept all of that as true because it's in the pleadings, just for purposes of this motion to dismiss, it doesn't rise to the level of egregious and malicious that you need in order to sustain that cause of action. But it seems like the judge, from what he was saying, is not inclined to dismiss these claims on the papers right now.
Whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Dillard can have an opportunity.
At a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and
right.
We're not looking to do that. This accounts for trying to conserve judicial resources.
That's right, and the court should be happy about that. They don't want to spend years and years and years on this. Let's just do it this way. Just third party all these people in. It's all the same events. Everything that she's going to sue them for has to do with what happened in the early morning hours of January 29th of 2022. It's all connected. It's all related. It should all be heard by the same judge. And look, the timeline is out there pretty far, 2027. The judge is right. There are personal injury cases and civil lawsuits that go on for 10 years. I don't know about 20 years. I think he said 10 or 20, but there are cases that can go on for 10 years that are very complex. Sometimes parties die and the case has to be stayed until someone's appointed to represent their estate, and they can take forever. And anybody who's ever been a plaintiff in a personal injury lawsuit can tell you that they can take forever. But let's try and streamline it at least here.
Trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there. Okay.
That's what he says. You're going to have to brief it. You're going to have to make a motion and explain to me why I should allow you to do this. And he's saying, okay, of course we're going to do that. Who else? Dr. Kempo, all caps, says, who else are the O'Keefes suing in this case? They're also suing the Waterfall Bar and CF McCarthy's, alleging that they overserved Karen, which caused her to be so drunk that she hit John O'Keefe with her car. And they were sitting in the jury box, sort of really like backstage, and they pretty much agree with everything the co-defendant has to say.
All right, let's hear it then from the Waterfall.
Yes, Your Honor.
Yeah, so the Waterfall and CF McCarthy's agree with everything, and then the plaintiff's attorney gets up and he's like, no, 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 we don't want to be in federal court. This should be in federal court. Hang on. So let's hear what the plaintiff has to say. Now remember something else, okay? I see a lot of comments flying by like, how can they bring this case? This is insane. She's been acquitted. She didn't hit him with her car. Well, you can sue anytime. You can sue anybody at any time for any reason. It doesn't mean you're going to succeed. Doesn't mean you're going to succeed. Just because a defendant is acquitted in a criminal trial doesn't mean they can't be sued for the same events. For example, the big, the most popular example of that is O.J. Simpson. O.J. Simpson was acquitted of the murder of Nicole Brown Simpson and Ron Goldman in criminal court, and then he was sued by the families, and the families got a big judgment against them. The civil jury found O.J. responsible for the deaths of Nicole Brown Simpson and Ron Goldman. So it can happen. The burden of proof in civil court is far, far less than in a criminal trial. It is just in a civil trial, it is more likely than not. So, I mean, my favorite example is just imagine the scales of justice. You just have to tip them a little tiny bit in your favor in order to win. A little tiny bit. Civil court also has much broader discovery. You can depose anybody you want pretty much, and you can ask them anything you want at the deposition, and all objections during deposition are reserved for the time of trial. So even if a deposition occurs and let's say Jennifer McCabe is asked all kinds of questions that she thinks are irrelevant or her attorney thinks are irrelevant, it doesn't matter. She's got to answer them. And then at the time of trial, the trial judge will decide whether that stuff comes into evidence or not. Also, if and when, because it is clear that whatever way they have to do this, whether it's bringing them into this case or filing a separate lawsuit, the Alberts, Brian and Nicole, the McCabes, Jennifer and Matt, and Brian Higgins are all going to have to hire attorneys to represent them. Plaintiff's attorneys like this man, I can't remember his name, right? Mark Diller, work on contingency, which means that they don't get paid until the case settles, if ever. They also lay out all of the expenses for the case. And in this case, there's already 8 parties here. Prosecuting this case as a plaintiff's attorney is going to be very expensive. And therefore, as a plaintiff's attorney, I would never take cases that were speculative, that I didn't think I could win, because I could work on a case for 10 years and not ever get paid. Plaintiff's attorneys don't bill by the hour. They get paid at the end of the case. Usually it's 1/3 of the recovery. If it goes to trial, some states allow for a larger retainer than 1/3. It could be up to a half. You don't take cases that you can't win because it costs a lot of money, right? They're going to have to pay for depositions and transcripts and experts and their time. There's a lot of money involved here that they're not going to get back unless there's a settlement or unless they ever collect a dime. Karen has defense attorneys who are paid by her car insurance company. And also, she probably had an umbrella policy. She's probably also got an excess carrier that is also defending her. And so her attorneys are paid. That is why you have car insurance, because if you ever get sued for a car accident, your carrier will appoint attorneys to represent you. It's not costing Karen anything for her defense. I don't know what her agreement with Alan Jackson is. I have no idea. However, there is no insurance company, in my opinion, that will cover the McCabes, the Alberts, and Higgins under any policy of insurance that they may have. There's 2 issues. Number one, they're claiming civil rights violations. I've never seen that covered by an insurance policy or a homeowner's policy. If they go on to claim an intentional act, that is something insurance would never cover. And so it's going to cost them a lot of money to defend themselves, because unlike plaintiff's attorneys, defense attorneys charge by the hour. And it's very expensive. We know Bob Alessi, as a defense attorney, charges upwards of $1,800 per hour, and he represents major corporations. In addition, the other defendants, however, Massachusetts State Police and the town of Canton PD, they will have attorneys to represent them in-house usually. Whether Proctor, Bukhenik, and Tully would have to hire their own attorneys because they're being sued personally, remains to be seen. But it's going to cost all of them hella lotta money to defend themselves. And this falls under the category of, as I've said, from the day this lawsuit was filed, you better want what you wish for, and karma knows your address. Because if you, O'Keefe's, did not sue all the people that were inside 34 Fairview because they're your friends, you're not doing your friends such a great favor when it turns out they're going to be brought into the case anyway, and now they're going to have to pay to defend themselves, and now they're not going to be so happy. And I've been screaming this into the ether since the day this lawsuit was filed. Go back and watch my original coverage on it, because that's exactly what I said, right? That's what they're going to do. They're going to third party all of them in. Let's hear what plaintiff's attorney has to say about that again.
But you've gotten,
Of course, I would
not how the
expect
court
that.
system likes this stuff to work, folks.
Right, I would expect the courtesy of a meet and confer to at least let me know.
Dude, you would expect the courtesy of him. You had no idea this was coming. Have you ever watched my show? You filed this lawsuit in the summer of 2024. Okay. After trial number 1. And I said, what are you doing? Why are you doing this? Why are you doing this? The statute of limitations didn't expire until January of 2025. In a wrongful death case, it is 3 years from the date of death, which is longer than New York. In New York, it's 2 years from the date of death. And there was time left on the statute of limitations. There was no need to file that lawsuit when you did. And so unless this is your first time and you didn't watch either trial, which we know that you did because wasn't he in court during the entire second trial? Wasn't he there? If you've been a plaintiff's attorney long enough, unless this is just your side hustle and you really like draft wills and stuff and handle custody cases and divorce, if you're a real plaintiff's attorney and that's all that you do is civil litigation, then you absolutely should have foreseen this, okay? There was no obligation for them to meet and confer with you. They're going to brief it. They're going to do everything the judge wants them to do. But I mean, at the very least, when you knew that Alan Jackson was getting involved, did you really not think it? And at the very least, did you not see Howie Carr's tweet this morning? Because we did, and we read it, and that's exactly what Howie Carr said. Sheesh.
Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward.
Might not be your decision, though. Might not be your decision. Because if they do go file in federal court, which they can do, they could move in federal court to have your case consolidated in federal court. And the federal court judge is going to be like, okay, you're coming to federal court. It doesn't matter. It doesn't matter where you brought your case. If the federal court judge says, I'm removing you to federal court, you're getting removed to federal court, which would really suck for us because there's never cameras in federal court. And so we're not going to get to see any of it. But again, you better want what you wish for.
The state court, we would like to have a state court Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor.
They're bringing back the brothers and the sisters. I want to say to my brothers and my sisters and my brothers, keep the faith. Keep the faith. That's a Jerry Garcia song. It's on the Karen Reed playlist, which is also linked below here. We have a Karen Reed trial playlist on Spotify, and every song is perfect.
We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint.
There you go. The judge has discretion to hear all of these cases in state court. There's no requirement they need to be in civil court. Patriotic, who knows, says only defendants can remove to federal court. I hope Karen Reed's team immediately file suit in federal court. Forget about judicial economy. Gloves off. They may, because the way this judge was sounding and his tone and everything, it sounded like he didn't want to let them third party in all of these defendants, and file the answer and the third party complaints all at the same time. So they may just be like, okay, you want to go to federal court? We'll go to federal court. We'll go over to Uncle Joe's house. I don't think that's the civil division. I think that's the criminal division, Uncle Joe's house, right? Which may be for the best. It'll be speedier. And federal court judges are no joke. They are no joke. They don't put up with any nonsense. You can't come in there and say, oh, we lost all of this Sallyport video and we just found it in a drawer. So sorry we didn't turn it over before trial number 1. But, and then Judge Canoni said, well, it's not really a big deal because she's getting another trial. No big whoop. No biggie. She gets another trial. No prejudice. Yeah. Federal judges don't play. They do not play.
There are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice.
And again, we could talk procedure all day, but what doesn't really matter is we know how slowly civil court moves. And the judge even said, we already have a scheduling order on this. And this case is not scheduled to go to trial until 2027 at the earliest, he said. But if you want a quicker trial date, I could get you on my calendar this spring if you'd like to go to trial then. And nobody really responded to that, did they? They really didn't respond to that at all. August of 2027, I think, is when we call that standards and goals in New York. You have standards and goals dates. So the court sets goals for how they want the case to proceed. And already, without anybody even asking for any extension of time to finish discovery and do more depositions and bring in more parties, the original order based on the case as it existed when it was filed was that it should be over by August of 2027. And so it's still a long time away. And they've got a huge team. I don't know how many attorneys Karen has now, but somebody probably kept count. And that's really the only things I wanted to go back and rewind with you. Now to the questions. Kelly Applegate, thanks for your 50. So I got my popcorn for this one. The judge did say he's going to try and issue a decision as soon as possible. And the next hearing is going to be in person. They were given the opportunity of in person or Zoom. And it's going to be November 21 in this court, even though this judge said, I'm moving to Brockton, which somebody said that's where Judge Canoni is. And I think that's correct. That all the motions will be due by then. And they're going to have to brief. They're going to have to brief their arguments as to why they should be able to bring in all of the other parties that we just mentioned in the way that they want to do it. And so this is going to be fun. We didn't even think there was going to be a camera in the courtroom over here in Plymouth Superior. And then Court TV went in there and did the Lord's work. And they filed that motion for media. And here it is. And I will also tell you, as a practicing plaintiff's attorney for over 30 years, my clients never came to conferences like this. Never. The clients never show up for these conferences, ever. Like never, ever, ever. The clients don't show up until trial and depositions. That's it. So the fact that everybody's here for this is highly unusual. I don't know if this judge has ever been on television before, but I felt like he wanted to sort of instruct the public about, things that he thought that they should be aware of, because a lot of people might not be watching me. And so he also tried to encourage them to settle. And so that was interesting, although far-fetched, in my opinion. And Mastad says this judge is sitting in the courtroom next door to Judge Frenier. Her courtroom, though, looks like it's in the basement of a hospital with the green walls. This is a nice courtroom with all the wood paneling and the wood right? Doesn't Judge Ranier's courtroom look like it's in the basement of a hospital with those hospital green walls and everything? So I am telling you that it's highly unusual that clients ever come to conferences like this. This is a highly unusual case. It's obviously everyone's interested in it. And the reason that Court TV is interested in it is because they know where their ratings lie. Because Karen Reed, thank you, Kelly, free 50. Emily says, was at the gas station in Sandwich, Mass, and the girl in front of me had your Cancun merch on. That's hilarious. Hilarious. Let's do a giveaway while we go through some of these questions. I'm gonna auction off a not auction off, giveaway. I'm gonna give away the new tour shirt that I made that I showed at the beginning of the show that you guys had the idea of, and I love this new tour shirt, and so I want to give it away. And so if you want to enter to win, everyone who's participating in the chat can win. Here's what you got to do. All you got to do is you got to, let's just say, leave it blank if you want all users that comment to be entered. Okay, that's what I'm going to do. So you can just comment and you will be entered starting, because sometimes if I put a word in there and everyone tries to put it in at the same time, then YouTube sort of, hides it as spam. So here's what we're going to do. I'm going to start collecting comments now. But however, you need to be willing to, only if you win, give me your name, your username, your address so that I can send you the prize. Okay? Okay. All right. Donnie says, I normally choose no violence except where Brendan and Paul O'Keefe are concerned. Sorry, not sorry. Okay. Thank you, Donnie, for your 5. This is a good time to point out that my viewers' opinions and my opinions don't always coincide. Thanks, Cajun Jumbo, for your 10. True Crime Kangaroo says, hello. Hey, Mel, you're top. I love it. This is actually a dress. It is actually a rental. It's an Anthropologie dress. I rent a lot of clothes from Newly, and I have a discount code that is also in the show notes below. So if you want to check it out, it's all like boho stuff. It's like Free People. It's like Anthropologie. And I think it's like, well, with my coupon, I think you get $30 off. So for like $70 a month, you get like 6 pieces that you get to choose and then send back after a month. And it's pretty awesome. So check it out in the show notes if you're interested. Thank you very much. Charles Argo is from South Africa, and he says that this defense lawyer is South African. You are correct. Nick Indy says, hello, my sister-in-law, AMG, who is joining Melanie today with me. Hello, your sister-in-law. Thanks, Nick Indy, for your 5. And Heather, I just pulled this up again because you have a fire dancer as your profile pic, which I love. So damn lucky. This is awesome, said John Miller. Sandra from Canada says, so happy right now. Would the McAlberts already know they are being sued, or are they finding out now like we are? Well, I mean, if they've been watching me, I've been predicting this since the summer of 2024 when this was initially filed, and they wouldn't know unless they saw Harry Carr's tweet this morning. But now that it's been officially announced in open court, now they know. So peace out if you guys are watching. Gen X Jen says, oh, look, it's the consequences of our own actions. Plaintiffs also Haas long until they drop the suit. Oh, sweetie, no. Oh, sweetie, no is here. And oh, sweetie, no says, PSA, Karen Reed's attorney is Damon Seligson, and he's originally from South Africa. You're right. And oh, sweetie, no sent me another awesome merch idea that I'm going to put up. And if she lets me use it and you guys like it, we can put that on t-shirts too. Kim Farnham says, I didn't think Mr. O'Keefe was a party in this. He is. I don't know if he was willingly a party in this or if they just filed it in his name, but Mr. O'Keefe is. I did not see him in the courthouse. Did anybody see him in the courtroom? I did not. Amand, thank you for your super sticker. I appreciate you so much. Hope Case Unwinder says, what's up, Melanie? Non-O'Keefe family, blind test case checking in. As Seligson argues the motion, LOL. Thank you for your 10. Sarah B. Creative has missed us all. Thank you for your 10. And Oklahoma attorney for true crime says, as a Section 1983 civil rights attorney, I am here for this. Thank you for your super chat. That wasn't a super chat. It was just a regular comment that I started for later, but that's amazing. Glamasu says, can Karen delve into Peggy and Paul's relationships? relationship with John and the children, I believe this is a real Achilles heel to their case. They can ask anything they want at depositions, and especially of the plaintiffs. And the plaintiffs, and this was something else that I said from the beginning that I was not happy about, is them bringing the niece into this, because when you bring an emotional claim for damages, your entire psychiatric history and all of your mental health treatment in your entire life comes into play. And all of that stuff is fair game. Thank you, Suze, for your super chat. Donnie says, what the heck? Is he retrying the case? And you were talking about, I guess, Mark Diller, it was Mark Diller that was speaking, right? I think it was. Why is he yelling? Said Tony. Listen, he's got to make his arguments. And based on the big bombshell that was dropped at the beginning about the 10 new defendants that are going to be brought into this case, he's zealously representing his client. Those are his facts as he deems the facts to be, even though he was there for the second trial. But I guess he still thinks he can win. So, you know, he's zealously representing his client. And so we got to let him do that. Storm Dancer said, yes, the O'Keefe family was vulnerable. The McAlberts did a number on them, and the O'Keefe family believed them. Thank you for your Ellen says, AJ looks bored, but we know his brilliant brain is working a mile a minute. He was on Billy Bush the other day. Maybe we'll play a little bit of that interview that he did with Billy Bush. So far, we have 1,181 of you who have been participating in the chat to win the tour shirt at the end. Bradford 287 says, how can they claim that Karen hit John and left him to die when it was proven in court that there was no accident? I think I explained that at the beginning. Thanks for your 10. That the burden in civil court is much lower. See OJ. Max Bang says, excuse me, sir, what accident? Yep. And look, they've already got ARCA on their side. All they need to do is hire ARCA to come in. They're already familiar with the case. They've already done a reconstruction. John O'Keefe was not hit by a car. A car was not hit by John O'Keefe. They can also call in so many of the other witnesses from Karen Reed's criminal trial. Dr. Russell, Dr. La Posada, the medical examiner, Dr. Irene Scorti Bello. Don't forget to hit the like button, everyone. Grandma of 6 says, is it not perjury, as it was proven that he was not hit by a car? Well, the perjury does not apply to attorneys. We're not in criminal court. We're in civil court. And he's just representing his client zealously. Denise, that's it. Thanks for your 5. He's allowed to do that because that's what it says in his complaint. BB says, so unethical of this lawyer who knows the facts to continue down this path. Listen, it's not an ethical issue if he believes that he can win this case, right? Like I said before, burden of proof is much less. And these are the facts as they present them to be. I don't know how they're going to prove that John O'Keefe was hit by a car. They've got to prove it. They do have the burden of proof, but I don't think it's an ethical issue for the attorney. Tony says, would love to know what's going through AJ's mind right now. He's like, where am I going for dinner? What kind of steak am I going to order tonight? Thanks for your 5. Hope Case Unwinder says, this is where I say I'm not his test case. Well, thanks for your 10. But the O'Keefes hired him. This was his strategy. I didn't agree with it from the beginning. I still don't agree with it, but it makes for good content for us, right? Don't get pizza for dinner. Don't go to D&E. Don't even go to Canton. Stay away from Canton. Janet Taylor says, how far is Plymouth from Canton? Can somebody just tell me? Yeah, I could map it, but I don't want to. If anybody knows, just let me know. Janet Taylor says to Karen, hang in there. To Melanie, thank you for explaining this. You're welcome. 1,342 of you are entered to win the tour shirt. Andrew Borelli says, if anything, the O'Keefes should have just sued the bars for over-serving John. This guy's drinking the McAlber Kool-Aid. LOL. Hashtag season 3. Thanks for your 5, Andrea. Strange Credulity is here, and she says, thanks, Melanie. It's a pleasure to listen to this with you. Thank the traveling Mary for Melanie Little. Oh, you're sweet. Thanks for tuning in from across the pond. The world is watching. If you're watching right now from outside the U.S., tell us what country you're watching from. It's amazing to see how many of you are outside, our international viewers. Max Bangs, it's 45 minutes away from Canton. Okay. Or from Dedham, Canton. Thanks. Max Bangs says, sir, you cannot try to presume an accident occurred based on emotion. The prior trial proved that wrong. Well, I don't know, Max. Maybe he must have experts that are going to be able to prove a collision, right? It's going to cost them a lot of money. Hope says, I object. Am I allowed to make an objection? Well, obviously not. But can I file a third-party motion? No, you can't. But I feel you. John O'Keefe was guardian of the children, not Karen, says Athena, the lawyer. Kay Willis is a realtor. She gifted 5 memberships. Welcome to all the new members. A lot of Canadians here. Istanbul is in the chat. Scotland in the chat. We have a lot of, and Denmark is in the chat. We have a lot of Irish and Scottish viewers, a lot. If you need to sell your house south of Boston and want to get the hell out of Dodge, Kay Willis is your girl. Josh says, didn't Turtle Boy get involved in the case years after JJ's passing? Yes, his first article, I know this because I just handled the mega motion, but I also have been covering Aiden's case for a long time. Aiden's first article on the Karen Reed case and the murder of John O'Keefe was August 18th, 2023. I mean, I'm sorry, not August, April 18th, right? April 18th of 2023. So some 15 months after the death of John O'Keefe, 15 months. Wendy says, all it showed was a woman sitting there with the strength of, this is when she was holding, when they focused on her hands. And I said, why is the cameraman doing that? And Wendy says, all it showed was a woman sitting there with the strength of a strong individual. Her hands fell in her lap, not an ounce of guilt present. She sat there like a proper woman who believes in her truth. Yes. Yes. Valoma Unstuck. Did this guy even skim through the 2 jury trials? Looking crazy right now, sir. Sit down. He was there. We saw him there. He was there for like every single day. Olivia knows because she was there too. Well, we were watching on TV and we saw him on TV. I don't think Olivia was in court. Hang on one second. Well, I mute some of these family chats because clearly they're not watching my show and they don't know that I can't be interrupted with their articles that they're sending me right now. So moving on. Commonwealth's crooked conduct says Karen Reed was the one that went home to be with Kaylee when the rest kept drinking, including JJ. Karen was the one raising those kids. Shame on them. Yep. We know. She homeschooled them during the panty. She did a lot for those children. She loved them. And those people forced them to testify against Karen, which is horrific because, like I said, nothing was gained by putting those children on the stand. If Karen Reed was convicted, would they think their whole entire life that they're the ones who got her convicted? By all accounts, she bought them expensive gifts. She spoiled them, according to JJ. And she was very generous to those children. She loved those children. And now that she's been acquitted, are they going to feel the guilt of, did we not testify well enough for her to get convicted? Is the whole family mad at us? The whole thing is just not good. It was not, in my opinion, nothing was gained by having those children to testify. I think it was far more damaging to them than it was helpful to the prosecution. But Hank Brennan didn't care. In fact, Hank Brennan cared so little that he read aloud the text messages between Proctor and his buddies, in which Proctor said something about the way that their father died. So he didn't give a rat's ass about those children. Ridiculous. And if you know, you know. I'm not even going to repeat it because it's disgusting. And the children, it might not even be true, but Proctor did text that to his buddies. And the children may have been told a different story about the circumstances of their father's death. So that's gross. Thank you for coming to my TED Talk. Shooter UK says, why on earth is he allowed to rehash the trial when she was acquitted twice? I don't understand this being allowed. You're outraged. Again, I think you sent this earlier, so hopefully you have a better understanding of the way civil court works. Rouser's mom, I don't think they can put Turtle Boy Aiden on the stand because he has an ongoing criminal case. Hopefully you can answer that after this is over. Thank you very much. It is my opinion that Aiden Carney's case will be long done by the time this case ever gets to trial. If they call him for a deposition, that could be also postponed until after the resolution of his criminal case, just like we saw Karen's deposition postponed in this case until after the resolution of her criminal case. Thank you for your super chat. Beth Ellen said it's going to be dragged out until March. It's going to be dragged out for years, at least August 2027. You know, unless, of course, they settle like the judge recommended, come to mediation. We could do a mediation. Yeah, no. Commonwealth's crooked conduct says, can we talk about the insanely severe emotional distress Karen has endured directly as a result of this corrupt allegation case? Dismissed it already. That could be in her third party complaint. She could sue for emotional damages against all the people that violated her civil rights. We got to wait and see. We got to wait for the papers. DF88 says, it disgusts me how much money these people have to piss away. Well, mostly it's the plaintiff's attorney who's paying for everything. So there's that. Shelley 1466, unless plaintiffs drop it, their attorney has to represent them a lot of hours with no payment, assuming contingent. He also could make a motion to be relieved as counsel if at some point they have some sort of a disagreement as to how the case should proceed. So there are ways for him to get out of the case without discontinuing. He can make a motion to be relieved and have them, give them time to find another attorney. But do you think he'll do that? Probably not. Thank you, Shelley. Josh said, it's going to be impossible for the O'Keefes to prove he was hit by a vehicle. The Commonwealth tried to do so twice. But, you can always find an expert to say what you want them to say. I mean, remember Judd Welcher? Remember Judd Welcher, Judd the Dud? And they were paid $600,000 for that opinion, by the way, as you know. Discworld Edge Witch from Canada. Merch idea, Melanie Little's extraordinary playlist with a fancy looking QR code to your favorite trial Spotify playlist. What do you think? I think that's very cute. I like it. I like it. Thank you. Beth Ellen, does Paul O'Keefe have a job? I don't know. Ms. Holmes, their attorney did a better closing than Hank Brennan and Adam Lally. I know, right? Bridget said Judge Cannoni is in Brockton Court. Ms. Bouquet is here. Hello, Ms. Bouquet. Hi, Harrison, if you're watching. I sent you some merch. I haven't sent you the headshot yet, but I will. Just have to get a manila envelope. That requires me to go to the store, so it could take a little bit. FKF 2025 says, is it right to assume that Colin is no longer off limits since this is now a civil case? Well, it's not been announced that he's going to be a defendant here. So there's that. They could sue him, but they're not going to. Aunt Bibi says, apparently I was naive about civil cases. I really thought the last two trials was the end of my high anxiety. We need to get ready and prepare because I suspect we're going to see a lot of PO smirks. Thanks for your 10, Aunt Bibi. Tara, if injuries entering the consciousness is the only requirement for negligent infliction of emotional distress claims, then why wasn't Patrick included? Because Patrick wasn't home. Because Karen Reed didn't have any conversation with Patrick about John perhaps being dead or being hit by a plow. He was sleeping over his friend's house. He wasn't there. And so that is why. Can the judge rely on the criminal record? No. The fact that she was acquitted, you mean? No. Nope. Totally separate case, totally different burden of proof, totally different standard of proof. And the judge is going to decide this particular motion to dismiss on the pleadings themselves. What is in the four corners of the complaint? Because there hasn't been any other discovery yet, no depositions. And so that is that. Crafty Councilwoman, merch idea, season 3, The Reckoning of Canton. Thank you for your 5. DF88, I mean, at the end of the day, whose front lawn was John on when they found him? It's not effing rocket science. Thank you. Thank you for that very much. Free 5. Ms. Holmes says, why didn't Karen's team file a motion to include the McAlvers before today? Or was this strategy? It's strategy. First of all, there are some procedural rules in Massachusetts that have to be followed. They may need to get permission from the judge. They may need to move by motion. And so this was strategic, and also this was televised. And so they were telling the judge what they intend to do. And I think it was okay to do it that way, because they still haven't filed their answer because they have filed this motion to dismiss, which has not been decided, although the judge did say he would have it decided before the next court date, which is November 21. Shooter UK, Karen Reed has amazing fortitude. How brave is she to pursue this until the end? I'm immensely proud of her for standing up for herself and the truth. Ocean Beach, new shirt front collective conspiracy back names. Shirt front collective conspiracy back names. Thank you. John Doe, MO, homeowners policies. Oh, Missouri? Are you saying Missouri? Homeowners policies in Missouri have claimed uses that permit a self-defense claim. And an attorney is appointed, the policyholder, live-in family for what it's worth. Yes, but also they have a notice requirement. And so, as I've said many times also before, you might not have been here, they have to give their insurance company notice of a potential claim within a reasonable period of time. I would submit, and I know I have a lot of insurance adjusters in the chat, not only bodily injury adjusters, but also property damage adjusters, etc., homeowners adjusters. It's been over 3 years, 3.5 years since the night in question. If John O'Keefe had fallen down, smacked his head on the concrete around the pool and died that way, and then was bitten by Chloe, that could have been paid under the Albert's homeowners insurance policy as an accident and a dog bite case. And they would have given notice right away, but they didn't give notice right away. And so it would be, in my opinion, it would still be disclaimed on notice. Lola says the judge reminds me of Mr. Hand from Family Times. Sage, so if she can't third party, does it get filed separately in federal court? We'll both go to federal court. Does the third party here avoid going to federal court? Please explain this. Thank you. I think I did already. They can do it. One, if the judge gives them permission to third party them in, it could stay in state court. If they file in federal court, the judge in federal court could remove this state court action to federal court and consolidate them there. So we have to see what they choose to do. But yes, if the judge did allow them to file the third party claims in state court and said, I do have jurisdiction to hear these 1983 claims in state court, that would avoid them going to federal court. Ellen says, what? How did Turtle Boy get dragged into this? The huge. Thanks for tuning in from Denmark. Thank you, Kelly, for your super sticker. JB for becoming a member. FKR 2025. Thank you so very much for your nice compliment and your 10 spot. Enter me. Love you, Melanie. Thanks, JB. Maureen, thanks for your 20. You're awesome. Donnie says, I promise I wouldn't be violent. I never would. They just upset me so much. I just want justice and peace for Karen. That's all I know. Just got to be careful what you say on the World Wide Web because, you don't want anybody knocking on your door. YouTube user says XOXO. Microdas is here. Fantastic show, Melanie. Your eyes are mesmerizing. Oh, thanks, Richie. Thanks, Richie. Hey, it's me. Thanks for your 10. Is this going to be frustrating for us? I need to prepare. Yeah, I'll talk you off the ledge. I'm always here to talk you off the ledge, but I'm also not going to lie to you. I will give you the straight dope. This is what I do. This is my wheelhouse. And this is what I do. So yeah, of course it's going to be frustrating for you, but you're going to be fine. You're going to be fine. It's also going to be like when Karma knows your address or their addresses, let's just say, it's also going to be pretty much like fire. Sorry for my questions from earlier. You have explained. Oh, that's okay, Ms. Holmes. That's okay. Let's take a look at what we're giving away here. Let's take a look at the giveaway. This is the new tour shirt that you guys have. Actually, you guys, it's an old time concert shirt that says Attorney Melanie Little XOXO Tour 2025. And it says, get your tickets at Attorney Melanie Little. And then it says, join the Snark Tank. And then on the back of the t-shirt, the concert shirt, it has the set list, which includes, hold on, all of those amazing sayings that we have collected throughout all the trials and other things too, things that I just say in general. Let's just say, and there's other products too that comes in. Oh yeah, it comes in a hoodie. It comes in this cool football shirt. And then of course there's other shirts that it comes on that have black writing on the back instead. And the link is pinned in the chat if you would like to purchase any of this. Oh yes, of course we also have tie-dyes because I'm a tie-dye girl. Look at that. Look at that. There it is, the tie-dye. And there's like 4 different colors of tie-dyes. And that's pretty cool. There, same deal. Then the white shirt. So, I just was playing around on Canva and here we are. And that's it. And that's fun. Here's the giveaway tool for a few minutes from now when we're going to choose the winner. Thank you, Ms. Holmes, for your super chat. Shine on you crazy diamond says, I'm sure the phone lines in Canton are running hot right now, and I hope the FBI is listening in. I don't think the FBI is done yet. In my opinion, it took 4 years for them to arrest Matthew Farwell. Will the civil jury know she was found not guilty? No, they will not. That would be more prejudicial than probative. Kay Huber, do you think that the McAlberts could force the O'Keefes to drop their lawsuit? I don't know. I don't know what kind of control they have over them, but that's an interesting thought, Kay Huber. Thanks for your 5. FKF, free Kelsey Fitzsimmons 2025 says the next hearing is in Brockton, 10 miles from Canton. Well, actually, he said he was going to come to Plymouth Superior to do that hearing too, so I don't want to spread misinfo. But you're saying it's 40 miles from Canton. So No, but he said that he would come back to this courthouse to see it, to hear it. I mean, to hear it. So thank you for your 10. But that's what he said, right, guys? Lisa says, idea for merch. My head just popped off, rolling down blank. Oh, yeah, that would have been a good thing for me to put on the song list. Thanks, Pinky. Thank you, Cynthia, for your gifting 5 memberships. Welcome, 5 new members. And Pinky says, pause to hit the like button, please, everyone. Awesome. DB Roach says, bring the third parties in, says everyone. Thanks for your 10. Angel says, 8 months a member. You rock, Ms. Little. Oh, thank you so much. A Sunflower Day is thanking me for explaining so clearly. You guys are awesome. Laura says, I wonder what the McAlbert's original plan was, not thinking Karen Reed would show up so early at 34 Fairview. A lot of people have a lot of opinions on that. A lot of people think that we're going to try and pin it on Lucky, the snowplow driver, and try and say that those marks on his arms were from a plow. I Love Dogs 1970. You won the merch giveaway on Saturday, but I don't think you were here because you haven't emailed me. So you get your choice of anything in the merch shop, but you need to email me, put, like winner in the subject, and then give me your address. I think they need your phone number too. Your address, your phone number, and your full name and your username. So I Love Dogs 1970, you already won, but apparently you didn't even know it. So collect your prize. Come and collect your prize. Okay, let's do the first one. We're gonna do the first giveaway because maybe we'll do more than one because that's how much I love you. Guess how much I love you? That's how much. All right, ready? 1,865 entered to win the tour shirt, and here we go. Do 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 do. Winner, chicken dinner, Shady, Norfolk County District Attorney's Office. You are the winner of the brand new merch, brand new tour shirt. Email me, winner in the subject line, your username, your real name, your address, your phone number, and the size of the shirt that you would like. Congratulations, Shady. Yay. Let me show you something else. That Oh Sweetie No designed. Tell me what you think of this. Another merch idea. Stop that. Where did she go? All right, she sent this to me. She's like, if you don't like it, it's okay. And I'm like, this is great. I love it. Tell me if you like it. And if you would buy a t-shirt with this on it. Okay, ready? Oh my God, how cute is this? Look, it says Block Island is lovely this time of year. Okay. And then there's me with a name tag on that says Melanie waving goodbye as the people are boarding the plane. Oh my God, how cute is that? That was drafted by or created by Oh Sweetie No. So if she lets me use it, you guys are interested in it. I think it's hilarious. I love it. You guys are so creative. And I love you with all of my heart. Let us see here. Oh, phew. Okay, one of my daughters who was at college got a jury summons to appear for jury duty. This is so ironic. And she's like, a plane right away, SCO buffs. And I like knew that I had it and I kind of forgot the date. And then yesterday I'm like, oh my God, I got to find that jury summons. It was for today, right? So in order to get an excuse for being a student, you have to send like a copy of their student ID and a copy of the tuition bill or their schedule. Thank God I found it yesterday. So then I emailed the court yesterday. Dear jury commissioner, here's all the proof. My daughter is at college and blah, 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 blah. And this morning I got an email that said, there's a delay in your delivery. And I'm like, oh, I sent it to .com instead of .gov. And then I thought it was Tuesday and I thought it was a day late. And then I sent another excuse like, I'm so sorry. I just realized that I sent it to .com and not .gov. And I thought it was a day late, but I came today because today's really Monday. And so I just got a response from the commissioner of jurors who said, your daughter has a student excuse. And I'm like, yay. Yay. Yeah, this would be cool as a poster as well, right? Yes, this would be cool as a poster. And then I can't sign them because I don't print them. I have a third-party printer, but that would be a cool poster. Yes, yes. Bag, tote bag. Karen did look fantastic today, didn't she? She really looked so good. So, daughter, if you're watching, you have been excused from jury duty. You have a student excusal. XOXO, Commissioner of Jurors from blank county. Let us see. Let us see. I do have the join button on my channel. Thank you, whoever, Elizabeth, you sent this to me, but I thought I have the join button on my thing, but thank you for sending me the article telling me how to do it. But sometimes if you're on a phone, you can't see the join button, or if you're on, yeah, I have to be on your laptop. Like, I'm not sure how that works, but I think some people see a join button, right? Are there people who do see a join button? Also, the link to become a member is in the body of the show notes below. There's an actual link. And like, if you're on an iPhone, you have to open up YouTube in your browser instead of you opening it under the app. And it's a whole thing. It's a whole thing. All right, so we got all that going for us. And anybody who says they can't send super chats, like Kurt, you have to send me a link to your YouTube channel. Your username won't do it. You spelling out your username won't do it. If you're blocked from sending super chats or you're blocked from the chat, YouTube has been really weird lately. Send me the link to your actual channel, even if you don't think you have one, you do, if you have a username, and I can correct it. I have to do it from my phone. I don't know what the hell's going on. The mods don't know what the hell's going on. YouTube is acting wonky. Linda, thank you for your super generous Venmo. This is Free Karen Reed and Justice for John O'Keefe. Sending love from Chicago. You're the best. Thank you, Cupcake Linda. She says, thanks for all you do to help us understand. And Terry, thank you for your Venmo. Says, thanks for covering this outrageous civil trial. Let's hope the defense can tie this up in a tight, pretty bow. Colleen through Venmo says, looking beautiful today. Here to watch, listen, and learn from you on Karen's case. Thank you, Colleen. I appreciate you more than you know. And Kathleen says, you're the best. Free Karen Reed, free Turtle Boy. No, Kathleen, you're the best. You guys are the best, because without you guys, well, first of all, I wouldn't have that 100,000 plaque behind me that I finally just unboxed the other day, because now we're up to 128,000 subs. But I am really the coolest mom now because I have a silver YouTube play button. So there's that. But without you guys, I wouldn't even have a channel. So you guys are the best. All right, let's see. Let us see here. Thoughts, questions, comments, concerns. Yay, I love dogs 1970. Sent me her information. Hooray! Winner, winner, chicken dinner. All right, so now I just need to hear from Shady, Norfolk County DA's office. Okay. Thoughts, questions, comments, concerns? Should we do another giveaway? One of Mel's Cupcakes has been here for 15 months. Thank you. Nutmeg Queen became a member. If you became a member today or you were gifted a membership, I have no control over who is gifted. YouTube does that randomly, but we do have special emojis that most of them were made during the Karen Reed trial. We have Wait for Us, What If Any, a solo cup, How Dare You, a Binky because Hank Brennan was a big baby. We had Boss Baby, which was from the Robert Tellis trial, but it also carried over to Hank Brennan or Brennan. We are outraged. We have a Colorado Buffs. We've got some Grateful Dead emojis, a Dave Matthews emoji. We've got a leaf blower and a solo cup and a smooth as butter for Alan Jackson. Oh, and there's Chloe. So if you are a member or you choose to be a member, don't forget about the special emojis that we have because we're recycling them. Nutmeg Queen became a member. Crafty K, thank you for your 10. Pinky idea giveaway for those who hit the like button. It's a StreamYard tool, and so there's no way for me to do it that way. It has to be they have to put a word in the chat, but that is a great idea. Kay became a member. Welcome. Mag said, to sue a private citizen for violating your civil rights, do you hand them your bill for both trials, loss of pay, etc.? Yeah, those are all special damages. I mean, lost income. You know, there are tangible parts of damages, right? Which can be calculated, like loss of income. The sale of her house, I guess that could be calculated if there was any equity in there that she lost because she had to defend herself, her attorney's fees. And then there are non-tangible damages, which are things like pain and suffering, emotional damages. And for those things, the jury decides how much to award. And that's a great question. Block Island poster or full front t-shirt, says Nick Indy. Thank you, Nick Indy. I'll get working on that. Dennis and Sue became a member. Welcome to both of you under one username. And Mark said, Glare, just show the outside interviews if you want to show the people after, Melanie. Who was he streaming to get it? Do you know? And is anybody going to the Ryder Cup? I want to go to the Ryder Cup this week. I usually like to go because it's at Bethpage Black, which is right here on Long Island. I've never been to the Ryder Cup, although I've been to the US Open golf several times, as well as some of the other tour events that have come here. But it was Tom CPU. Okay. Because I like to go during the practice rounds because that is when the players take pictures and sign things. And so guess I can't go on Wednesday because that's Turtle Boy's hearing, but tomorrow, Kelsey Fitzsimmons' hearing has been adjourned. So that's not happening tomorrow. So if you were planning to go to whatever court that was now, I can't remember, Lawrence District Court, it is not happening tomorrow. And I'm not sure what the new date is quite yet. So hang on. Let's see if we can find Tom CPU, give him a like and a hug and a sub. And we can see if he had some interviews after court. Was the audio okay? Because sometimes the audio is terrible because of all of the mainstream media channels sucking up the internet signal at the courthouse. AJ spoke to the media. All right. Let's see. Oh, I got it. I got it. Thank you to Tom CPU. Seeking Justice with Tommy and Boston Mike. That's the channel that I'm streaming it from, and they always give me permission, so it's okay. Don't worry, he won't strike me. And CPU Mod 1 is here, and that is Tom CPU's sister. And I got to meet her when I was at the Wilbur, and she's awesome. All right. And we love Tom. We love you and your brother both. Because he's out there every hearing. He's always doing the Lord's work. He's out there. He's with the camera. He's talking to the people. Let's see how the audio is. And can even.
Aaron, do you want to say anything real quick about what's you're going on the offense at this point?
We're trying to.
So it's a whole change in tactic, right?
I think we're a little offensive during the criminal trial. I need a pull back.
Yeah, I'm saying, hang on. Y'all didn't even let her get a blocking back.
Okay.
We can move quicker. One second. What an affirmative claim is. It's an affirmative claim against third-party individuals. That's exactly what we intend to bring.
But the idea is to get them combined to save the court time and money.
All the same individuals are involved. So that's exactly right. It's a matter of judicial economy.
You respond to this.
Oh, I'm sorry. Is the audio too loud? I boosted it. I'll put it back to Tom's volume. Usually people complain they can't hear it.
The judge might take longer if you do this. You have all these.
Well, of course, because it becomes a bigger case, more voluminous, right? It's a bigger case with more claims. That's exactly what this case calls for.
How about
the days of Karen Reed being on the defense are over, right? That's what started today.
What do you think about what do you think of the judge?
The days of Karen Reed being on the defense and the defensive are over. That started today. That's awesome.
Saying trying to resolve this. Can you resolve this out of court?
Every single civil case should at least have that on the table.
Can you resolve this out of court?
Every single civil case should at least have that on the table. Civil cases are built and designed to be resolved if they can be. We'll see.
I guess the thing is, was that something that you guys would like to do, though? I mean,
say it again.
Was that something that you guys would like to do, or you seem to want to make a point?
Anytime there is a civil case, look, civil cases are not about making a point. They're trying to seek the truth, right? And that's what Karen's going to do with this civil case. We're going to try to get the truth out there.
That's interesting that he said that, because he said the other day on Billy Bush that it was all about money. It was all about money, not seeking the truth. It was about money, and that plaintiff's attorneys are only looking for money. Hold on.
To seek the truth, right? And that's what, look, civil cases are not about making a point. They're about trying to seek the truth, right? And that's what Karen's going to do with this case.
Well, for her, she's going to
get
try and seek the truth.
Like I said, the days of her being on the defensive, those days are over.
So you still
And
consider a,
everything-
you still consider a settlement then?
Everything that you heard in there was basically parroted. Every single word that you heard in there was basically parroted right from Michael Morrissey, right from the prosecution. They lifted it right off the prosecution's closing argument. And maybe somebody should check the tapes. Because last time I checked, those arguments were put forward in front of a jury, and the jury spoke very, very loudly. Not guilty, and not just not guilty when the jurors were asked. Innocent. Those claims are false, and they were proven false, and they will be proven false again. But in terms of what you just asked, should this case be resolved, we're always open to resolution. We'll see. We'll see. Depends on how reasonable the other side is.
Damon,
Damon,
Damon, did you want to say anything? I mean, you've been sort of point person on this, or?
Well, Ellen does it all that's in its perfect way. So, you know. That's okay. Everyone heard. But nice to see you. Yeah, good to see you again. Yeah, I remember. Back into that. Yeah.
Thanks, Tracy.
Okay.
And James and Fairy Raven.
Murdered.
Join me for a Court TV true crime series where we take you from the crime scene.
All right, that's weird. I don't know why Court TV's audio was in there, but that's the end of that. And so he said there's always a chance of a settlement, depending on how reasonable the plaintiff is. But I don't know. As a matter of principle, I would not settle, but that's just me if I was the defendant in this case. Where were we? Thank you, Tracy. This is Bless Your Heart. If you stick around till the end, we're going to do one more giveaway for one more t-shirt. Our concert shirt. Upstage Center became a new member. Welcome. Thank you, West Virginia said I would like that picture on a coffee cup. Oh, the Block Island one? Okay, sounds good. That's what Fairy Raven said too. Thank you for your super chat. Rose said, it's outrageous and appalling that Massachusetts continues to try to persecute those they consider witches. Karen Reed, Penny McGee, Kelsey, etc. Yes. 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 Okay, I got an email from Paula. Okay, so Paula, are you shady? Norfolk County DA's office. I'm going to assume that you are because that was the only giveaway today. Unless somebody named Paula sent me her information without winning. So I think you're the winner. But also just remember to tell me, I'm okay. I see the same profile pic. Okay, we're good. Rose, it's outrageous and appalling. Yes, I know. Isn't it fitting though that Kelsey Fitzsimmons case is being heard in Salem, and the judge in that case is like, hey, Canoni, hold my witch's brew. I'm going in. It's bad, but it makes sense. Makes sense. It just makes sense. And also something else that I found out about Kelsey Fitzsimmons' fiance, the one who now took her baby away and has a restraining order against her, her ex-fiance, and is the reason why she's sitting in jail. And I have verified this, so it is true. You may have seen it out there floating on the cesspool. There's a picture floating around of Justin in a hot tub, naked, of course, from the waist up, in a hot tub that was posted on some sort of website called Are We Dating the Same Guy? And this was posted by someone who was dating Justin, not only while Justin was engaged to Kelsey, but also while Kelsey was pregnant. And in the post, the woman wrote, he wants to take me to some fancy steak restaurant, something like that. But he says he's going to be MIA after March 20th. What's up with that? Is anybody else dating this guy? March 20th was Kelsey's original due date for the baby. The baby wound up being born early by, I guess, many weeks, because we know the baby was born mid-February. So there's that. So when everyone says, Kelsey Fitzsimmons is a horrible person, look at what she did, this, that, and the other thing. Here's what was going on behind the scenes. And let me tell you something. If I was that pregnant and I found that out, that my fiance was out there trying to get with other chicks, and I was hormonally pregnant, I would probably be doing a lot worse than not breaking picture frames and knocking all the things off the kitchen counters. Okay. So there's that. Yeah. Darvo, all of it. Thanks, Rose. Thanks, KJ22, for becoming a member. So I have Kelsey's address where you can write to her. And if you guys are interested, I will put it up for you. Please send her notes of support and cards of support. And I do have her address where you can send them in jail. Originally, I said send them to Bradel's office, but it'll be too hard for them to give them to Kelsey. So if you send them directly to the jail, she will get them. And she could really use it. Kirsten, Honorable Daniel O'Shea nomination hearing is on YouTube, Mel. It speaks a lot of who he is in a courtroom. Highly recommended watching. Thank you. Highly recommend watching. I love you with all of my heart. Thank you, Kirsten. JL, we'll give you half of nothing. Thanks for your super chat. Liz loves the law says from Australia. Happy Tuesday morning from Canberra, Australia. It's a great day when you wake up to Melanie Live. Oh, thank you. And Brigitte says, just got the concert shirt. I will wear it for everything. Court date for Karen Reed and support attorney Melanie Live. Oh, you're sweet. You're so sweet. And yes, they do ship internationally. It's a third-party vendor. I have no control over it. It's not as fast as like, Amazon, but it's pretty fast. You guys that have gotten merch from my spread shop have gotten it pretty quickly, right? It's not terrible, but they print to order. So I don't have to do it myself. There's no middleman. They do it. And it's easier for me and also easier for you because you get it faster. Before we do that, let's take a look at what's on the reverse of the concert shirt. And it is the set list with a peace sign, because you know me. And the set list starts with God Save Us from the Commonwealth, followed by Call Me Alice. Show Me the Papers, spelled exactly that way. The World is Watching, Grave Concerns, Talk Amongst Yourselves, There Was No Collision, Buy the Tickets, Pin It on the Girl, Under Her Eye, She's Telling Them Everything. We're not buying what you're selling. Upside Down, Inside Out, Narnia of Norfolk County, followed by All Hail King David and Alessi Scissorhands. That's a really cool jam. The two of those songs together, one into the other, if you know, you know. Followed by Hello, Have You Met Me? Never Lie to the Ice Cream Truck, One-Way Ticket to Block Island, Love Me Some Betero Letters, and this one's for Olivia. It's called Hyperlink Me. Followed by the closer, For the Love of the Traveling Mary, and then a double encore, We Ain't Got No Quit, followed by I Love You With All of My Heart. It is on the t-shirt. It's on the back of the t-shirt. That's what the back of the t-shirt says. The front of the t-shirt is the tour poster. I mean, the tour logo that I showed you earlier with a picture of me on it. And then that is on the back of the shirt, as if, it's like kind of like I still have concert shirts like that. It has all the tour dates on the back. And so that was the idea. All right, here we go. We're going to do one more giveaway for those of you who have remained. And again, if you are the winner, only if you are the winner, like Shady, Norfolk County District Attorney was the last winner. Now we have over 2,000 entries, 2,149. All you need to do is put a comment in the chat, any comment. But if you put multiple comments, you will only be considered one time. Okay? Isn't this fun? All right. True Crime Kangaroo says, I love how you say papers. That's from Goodfellas. Johnny 2 times. Was it Johnny 2 times? Got to get the papers. Give me the papers. Get him the papers. It's Johnny 2 times from Goodfellas, right? I think so. All right. One more time. We're going to go one more time. Again, Thunder Horse, I can't do anything without the link to your channel. Can't do anything. There's nothing I can do. YouTube is blocking people that they think are bots. So there's that. Ready? And 2,243 people. We're going to do it again. And here we go. Do, 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 do. Oh! And the winner is Jody Mitchell. Jody Mitchell. I'm guessing that's your real name. Email me. My email is in the show notes below. You got to be smart enough to find it. email me your name, address, phone number, put winner in the subject line, and the size tour shirt that you would like to be gifted from me because you're the winner. You're the winner. Well done. All right. Tomorrow, I don't know what we're going to cover. If I go to the Ryder Cup, I'm not going to be going live, but you're going to want to make sure that you have your subscribe button hit. You're going to want to make sure your notifications are all and that you have notifications enabled on your phone because otherwise you won't get the notifications that you have enabled. You are also going to want to come back here at the very latest. I'm coming back on Wednesday for Turtle Boy's live hearing. And that'll be at 1:30 in the afternoon because the hearing is at 2:00. And so you're not going to want to miss that either. Thank you to the moderators for keeping it classy today because it's not always easy. The merch link is pinned in the chat if you want to go buy your own tour shirt or any of the other merch. And we'll get this Block Island stuff out for you guys. And because it seems to be overwhelming that you like it. Okay. All right. Stay cool, stay kind, stay classy, stay safe out there, my friends, because it's not easy. And I'm going to see you real soon. Peace.